All right. Hello, everyone, and welcome to another edition of Fire Law Roundup. Today is June 20th, 2022, and I'm here with my colleague, Brad Pinsky, and we've got a couple of cases for you. So we're looking forward to bringing you those. Before we get into the cases, we got a couple of emails this week, and I want you to know we take the feedback seriously. And one of the comments was that we sort of were assuming that people have the blog in front of them and basically have access to all the information that we have. And that's was actually our assumption. So what we need to do, what the request was, is that we provide a little bit more factual detail and where appropriate, the case name and so on. So we're going to be more attentive to doing that. I know my assumption is you've read the blog, so you're somewhat familiar with the cases, but I also know that sometimes, and it looks like Brad just dropped off, so I'm not sure what happened there, but I'm sure he'll back in. So at any rate, the concern is it's a fair one. And let me see, Brad is actually texting me, and let's see, I'm just going to tell him to log back on. Okay, very good. And we'll be up and running. So, but we do take those seriously. And you know what? I really appreciate the fact that people take the time to reach out to us, because that's important to us. Our listenership is growing now. We're up over 400, and thank you for the support. That means a lot in terms of our ability to keep going with this, by the way. So we really, the next sort of milestone, one milestone is 500, but in order to get to the sort of the next tier in terms of YouTube, we need to get to 1,000. But once we get to 500, I'll be selecting a random, or we'll be selecting a random person to receive a copy of my book. And, then it's off to 1,000. And once we hit 1,000, then that's going to be a big deal. Also, for those of you who aren't familiar, we are doing 10-minute segments of these. I know 40 minutes is a lot for somebody to sit down. And I know even myself, when I'm looking at YouTube videos, I'm saying, oh, it's 40 minutes or 10 minutes or 8 minutes. I think I'll take the 8-minute, 10-minute one. So we are providing those. Just go to the YouTube channel. You see, we call them the Fire Law short takes, and a little bit more digestible for you. So, but at any rate, Brad, I'm doing all the talking. I like it. It's time for you to sort of take it away for us.
Well, let's. We've got some interesting ones. We have some very, very complicated, issues this time. So let's start. We're going to start in San Francisco, and this is the issue noted on your blog as San Francisco firefighters are fired over COVID-19 vaccine mandate. God, I can't talk today. And the topic is. It's funny because these are things that were already litigated way back. So seeing it now, it's almost kind of, enough already. But so here, 21 San Francisco firefighters were fired for failing to comply with the city's vaccine mandate. And I just want to note, right? So they were fired. Do we know the dates they were fired? Because I have all these issues, which are kind of interesting today.
I don't, but my sense is they're in the complaint. I mean, it's a lengthy complaint. I'm looking at it's 179 pages. I know that's not all the complaint. There's some attachments and some different things in there. So I'm sure it's in there, but I agree with you. It's interesting in that now time has gone by. Our perceptions of it have changed, and we'll see maybe if the courts are going to look at it a little bit differently as well. I think that's going to be something to consider.
And I'll let me explain the facts, and then I'll explain. You and I are going to be on the same page. But so they want reinstatement. They claimed that they were discriminated against based on religious bases, and they claimed that the city failed to accommodate them under their religious beliefs. Now, I got to tell you, I don't know a lot about San Francisco, but it's a pretty liberal city. So, except, look, I don't want to get controversial. A lot of people say, well, so liberal, but you're mandating a violation of rights by, vaccine mandates. I won't go there, but liberal has a new meaning today. I just don't know what it is. In any event, what the complaint alleges is that they all had sincere religious beliefs. And I don't think there's a question that they didn't really have these religious beliefs. And they provided convincing evidence that they held these beliefs. But according to the city, they had no way to accommodate their religious beliefs. Now, that's where I want to come back to today, because today versus a year ago, maybe different knowledge, right? And I'm going to pick on the government because I can, but we'll get back to that in a second. So they said that, the CDC's understanding of whether or not the COVID vaccine had limited limited effectiveness, or whether it diminished the transmissibility, right? They were still trying to figure out the vaccine's effectiveness. But so they said, well, it's speculative. So they claim that the defendants discriminated against them and took adverse employment action based on their good faith beliefs. And there have been a number of these suits. But the dates, to me, is where we are in our understanding of COVID and the vaccines. That's what I think is important. In any event, they claim that the city violated the religious constitutional rights, even while imposing the least, right? It's kind of double negative, but the least narrowly tailored and most restrictive rules and requirements based on the COVID vaccine policies, et cetera. So they were fired. They want reinstatement. Here's the interesting thing. So let's go back to this. So the question is about an accommodation, and I am never going to get away from it. Why is it not acceptable to wear a mask and have that not be an accommodation? Because if you replay the 10,000 times that Fauci and everybody else are on the news saying, well, masks, double masks, 100 masks, I don't care, put however many masks you want, put a Darth Vader mask on if you want. The masks are supposed to prevent the spread and the transmission both ways of, right? And especially an N95. So why is that a reasonable accommodation? Why are we going to the
They also
vaccine?
make a P100. So you could tell them you got to wear a P100.
I don't care if they wear SCBA. I mean, why is there no accommodation, and why is vaccine the only accommodation? So I think it will be very interesting, for a court to look at this issue now versus a year ago versus 2 years ago. Haven't we seen the vaccines now have limited effectiveness, new variants? And I'm vaccinated. This isn't a political issue.
I am too.
But how are masks not better than the vaccine?
I look at it, and as attorneys, they drill this into our heads, starting the first day of law school, that you craft the issue so that it's answered in a way that's going to support where you want to get to. Okay. And the firefighters are going to argue that based on my circumstances, should I have the right not to get the vaccine, whether it's religion or race or whatever other parameter may be, my particular health condition, my disability, all those things. Should I be required, okay, to undergo this sort of experimental kind of vaccine, which I think we're beyond that now, but should I be required to, or does our Constitution, do all the laws protect me in this situation? So that's sort of the question the firefighters are asking, okay? From the employer is saying, don't I have a right to require my employees to do this in order to protect them? And depending on which question is really the more, because they're going to go to court, and the firefighter is going to argue their question, the employer is going to argue their question. The court then has to say which one of those two questions is the real question.
But the least, the standard is there a lesser invasive option, right? Which could be accommodated.
Well, not if the question is, does the employer have a right to impose something that the federal government has said that everyone ought to be doing? So I think, and fine, this is COVID. we're at a certain point now where we've managed the fatalities and some of the bad outcomes and everything. We weren't there 2 years ago. And so the rulings here may have legs in a different context, such as Ebola or a fatal disease. And it's the same principle. If the employer has the ability, when the federal government, the CDC, WHO, and everyone else says, we need to be vaccinating everyone, and we're sending you to these kinds of emergencies where you're going to be exposed to Ebola or whatever else is coming down the pike. And as an employer, you have the right to require this of your employees. If that's the question the court sees, then I think there's only one way that they can answer it. And they answer it the same way they did in the 1800s and early 1900s when it came to smallpox and polio and a lot of other things. So on the other hand, if it's viewed from the firefighters' perspective and their question is going to predominate, then we get to those other issues. So who knows, and I can see two judges, depending on their, perspective, going in different directions on it.
I still get, I'm guessing you don't agree, but I still get to the question of on either issue, is there a least, is there another option that's less burdensome on the employee? And to me, in all other cases, right, with reasonable accommodations or lesser invasives, or there's always the question of is there another reasonable option to accommodate these individuals? And how do we not say a mask is better than the vaccine today?
Well, that's my point is, do we even want to get, will the court even entertain a discussion on how effective the vaccine is versus how effective the mask is? Or will the court just say, look, the CDC said it, the employer had a reasonable basis for doing this, and that's as far as we're going to go? Because up to this point, most of the courts seem to have been going in that direction.
Yeah, and I don't disagree. If I was the judge, and I can't be, apparently, I must have finished too high on the law school plan.
Don't get into it. We're gonna we'll get ourselves sanctioned by a court. We
Sorry for any judges that are watching in their spare time. So, but the if I'm the judge, what I'm saying, I am looking at what is the goal you're trying to achieve, what is the method of getting there, and is the way you're getting there, again, is there a less burdensome option to achieve your goals? And and when it's a balancing of interest tests, you look at the employer's need, which is protect his employees, protect other employees, protect the public.
Yeah.
Okay, and then you look at the employees' rights, whether it's disability or emotional or religious in this case. And then the problem is you can get there both ways by wearing a mask. And how can any fire department or ambulance service today say, well, wearing a mask isn't viable? That's what we did for 2 to 3 years. So I have a hard, especially now based on new research, when it's clear that the effectiveness wanes. This is also a continuing burden, right? To say you have to continually get vaccinated with every new thing that comes out. So the employer now would be in the position of saying, now you need a booster, you need another booster. And here's my, this is where I always would have argued it. I never saw this argument during COVID, but here's my argument. Flu vaccine, not mandatory. Hepatitis vaccine, not mandatory. You can get a waiver.
Well, really? For hepatitis B? Oh, really? I thought that was mandated.
Right. The hepatitis, you only have to offer it and you can get a declination, but it's not mandatory. HIV has vaccines. Why isn't that mandatory, right? So there's all of these things. Bloodborne pathogens, what do we still say? Wear gloves and a mask, right? Tuberculosis, TB, we offer the tests, but I think we're taking irreconcilable different approaches to the flu, which is just as bad as COVID, to the to hepatitis, which could be just as bad, although not as transmissible, but maybe in the ambulance, right? So why aren't we taking the same approach? Prophylactics through use of gloves and masks stop the transmission. I think the approach to mandating a vaccine is incomprehensible.
And I think your argument makes a lot more sense today than it did 2 years ago.
Right.
and I think we're in agreement on that. So, hey, it'll be interesting to see,
Correct. But I think the point is, kind of to wrap this up, anyone who's saying, I want to challenge it today, they go to an attorney, the attorney says, oh, that case was over a year ago. I think the facts have changed. Yeah. I think we've seen that the vaccine is not a one-shot cure-all forever. In fact, it seems to have limited duration, a limited effectiveness. And shouldn't that weigh on the factor of, okay, isn't there a more effective way to deal with this, such as a mask?
Yeah.
So, okay.
Good point.
Well, let's head to Indianapolis, where they're having one hell of a heat wave. Okay, so this is going to be rare for me. Normally, I summarize, but you spent 1,000 pages on this summary, and I couldn't possibly remember it.
I have lived this case. With numerous firefighters, and I've done it from the managerial perspective. Okay. I've seen it as a firefighter among other firefighters. I've seen it as a company officer among other firefighters, and I've seen it as a chief among other firefighters. That's why I wanted to put it. So it's not my perspective. I really want to have the actual words of the court explaining the facts, but they resonate with me because I've seen this. And I really wish we were better at being able to help people like this. But at the end of the day, if you can't get to work, we can't keep you on the payroll. I think that's the end of it. But I have a lot of sympathy for him in terms of his situation. But let's get it. Now I'm getting ahead, and I'm doing exactly what I started out by saying we shouldn't do, which is we didn't explain the facts. So
we'll explain the facts. There is no way I can do this other than to go through. I tried to parse out some of your facts. It didn't cut much down. So this is going to be a very long reading for people.
Well, I'll give it to you. I'll give it to you quick if you want. Sure. And I'm going to butcher his name, but it looks like it's Sanjeev Neal, was a firefighter in Indianapolis. And he, according to the complaint, he was suffering from anxiety, depression, post-traumatic stress. Bottom line is, he also claims he was bullied and ostracized by firefighters in the academy and also by his superiors, which we know that happens. It's part of,
and maybe by the doctor. Was one of the
lines. I had maybe a different take on that. I'm not sure. Sometimes when people have certain conditions, they may misperceive what someone does. But certainly, if the doctor did what was accused, then certainly that there was. But sometimes people that are under a lot of stress misperceive something that is fairly innocent and interpret it in a way. And that doesn't mean anybody's right or wrong. It is what it is. But bottom line is, he had these clearly diagnosed conditions, and he was struggling to get to work. And he had been off. I guess he was off injured. And bottom line is, he needed help. He had been off for an extended period of time. The department, what Brad had suggested is, I provided a lengthy sort of explanation of all the things that the department had done to try to get him back to work. That's an indication that the department didn't just say, hey, you called in sick three times in a row, so we're going to get rid of you. The department did a great deal to try to assist him and get him back to be a productive member of the department. They suggested that he go away. At the end of the day, nothing that they did really seemed to help get him back to a point where he was going to be able to work, and he ended up being terminated. And he sued to try to get his job back, and the court basically said, coming to work is an essential function. If in order to be able to work, you have to be able to satisfy the essential functions of the job, and one of the essential functions is you got to be able to come to work. And if you can't come to work,
he also failed to notify them on multiple occasions when he wasn't coming. He had a number of no-shows.
Right. So it wasn't that. And you're right. It's not just wasn't just the no-show, but it was the what we call AWOL, but absent without leave. But the bottom line is, the court essentially said, and I'll try to find the quote here because I thought it was pretty good, but where is it?
And as you're looking, I'll say, I mean, there's a number of instances in August of 2019, he failed to report to duty without notifying his superior officers. He then was suspended for 48 hours. And then on August 22nd, he doesn't show up to work, but again, without notice. So even 2 days later, he doesn't show up. So, this is one of those issues, as you're saying, where the employee is not doing his job at the very least notifying them, I'm not going to be there. And that has real effects on employers, right? You can't schedule somebody else. You have an open shift. If you have minimum staffing, you're violating that. I mean, there's all sorts of problems that come from that. Just to throw this in, he was also didn't have his EMT certification that lapsed, and that was required. This is a hard one to stick up for the employee, despite what's going on. The employee in some sense needs to help himself. When you're done looking at the quote, I'm going to give you something that I don't think the employee thought about, but go on to.
No, go ahead. I couldn't find it, but
okay.
basically it's the court said you have to come to work. It's part of the job is to come to work. And as I think about it, I wonder if the attorney, and I'm sure the attorney made it the best argument that the attorney could in the case, but I wonder how long the attorney would have employed that person as a paralegal
Right.
if they hadn't been coming to work, to the same degree that he hadn't been coming to work.
Right. And look, we should add in, because they apparently have some sort of light duty, because he was on some sort of modified or limited duty, and he even didn't do that. So that all goes to bolster you got to show up. That, showing up is an essential job function. You can't work for a home and be a firefighter. So one of the things I just want to throw out quickly is it was interesting that they didn't appear to raise the Family Medical Leave Act, because, and I won't get too far into this for our viewers, but if you're a career department and you have not attended Curt and my FMLA, 3-4 hour in depth, the first thing that struck me is, wait a minute. If you claimed FMLA, this is an intermittent leave. He didn't necessarily have to let you know if you should have known, and maybe 48 hours early, if he's having issues, the employee or employer should have known. Now that he didn't raise family medical leave, because most attorneys aren't great at understanding it, but this could have, I'm not saying it would have, could have received extra attention under FMLA, because the employer should have been aware that he had a qualifying medical condition that may have gotten him 12 weeks of unpaid leave. I didn't calculate how much leave he used if he had it, but it certainly seems like something that should have been raised.
That issue was so in the front of my mind when I read the case that I went back and got a copy of the complaint, because I said he had to have alleged an FMLA violation, because there's a lot there. There's a lot of little nuances that maybe you didn't do this just right. So I figured at least they'd throw in an FMLA allegation. Nothing.
Yeah.
Nothing.
Yeah. And maybe that would have changed the outcome, maybe not, but it just shows great minds think alike.
Yeah, well, also as I read these cases, for the folks who are familiar with how we do things, I add them into my database, and I have categories. And one of the check boxes is FMLA and so on. So I want to get it right. I want to make sure that when I say 6.8% of the lawsuits against fire departments allege the FMLA was violated, that I have accurate information. So that means I got to go back and read the complaint, but it wasn't there.
Yeah,
no allegation.
Maybe they missed it, or maybe they made a calculated decision.
And maybe the department did it right, and they had all their boxes checked. So
right, they may well served all the notice of rights and all that. So okay, let's go back to where we never seem to leave, New Haven, Connecticut.
Frank Ritchie's out of there. Frank is retired.
You can't blame him, but. I almost loved this issue. I will explain it very easily. I almost loved this issue until I got to the end. I'm like, darn it.
Well, that's why I kept that from you, just like the court decision did. They kind of held it back, but let's lay it out for everybody first. So
we will. And your blog makes me feel a little better, because you cite us to another better suited case. Right. But so here we have the city of New Haven has has 99 first place, right? Scoring 100, which I was surprised. There were no, I don't know, maybe New Haven doesn't give
I
5
think
points
maybe they
for
made the test
military.
a little easier. They decided, you know what, let's make the test a little easier.
Maybe, but but normally, like in New York, you can get 5 points for military service, which is pretty common. I was surprised that there were no 105s or 104s for military service, but I don't know. So in any event, totally on side. So 2 persons who who did not finish in the top tier are your plaintiffs. That's the most disappointing part of this. But so there's a 99 first place finishers, and the city, which I think it's fine. I can't come up with I mean, I know there are reasons, but I personally think it's fine. They took a lottery system to how do you choose amongst 99 equal people. Now you could say, well, we're going to interview and we're have a series of questions, but that's subject to a ton of challenges. As soon as you open your mouth and start asking questions, and then God forbid follow-up questions, you get more challenges. So here
and they have a very bureaucratic civil service system too. So that, and a lot of the allegations in the lawsuit alleged they weren't following the civil service regs, even with the what do you call it, the lottery. So I don't know if the civil service regs would have even allowed them to go to some sort of an oral board or some sort of assessment type of thing. So that was, I think, a limitation that caused them to go with the lottery system.
Right. So now I'll just note the other case you cite to on the blog, which is more interesting, but makes a more foundational challenge, which I think is very good, which is saying, listen, we're not fighting the lottery system specifically. We're fighting the fact that you didn't go through the process with civil service to change how you're going to make the decision. So it's a process based that you should have changed the rules properly, not just willy-nilly change the rules. So that's a better argument. I don't know that it wins the day because effectively the test stays in place. Don't hire somebody off the list, change the rules if you can do that after the exam. And a lot of states will say you cannot change the rules, how you monitor the exam based on the exam results.
I think the U.S. Supreme Court said that, I think.
Yeah, that might be.
In a New Haven case, I think.
just saying. So, in any event, so this case unfortunately doesn't get to a good conclusion because the court dismisses the case not based on the merits, but based on these 2 people who sued were not in the top tier. They didn't have what's called standing. They didn't have a defensible position. They didn't have a protected position to challenge this because they weren't personally affected by this decision. So unfortunately, we never get to the merits of any of this. You got to go back to the other suit. So that's
interesting. That's why I was reading the case. I'm reading the case. And then finally at the end, they say, by the way, the case is going to be dismissed because they weren't in the top 99. And if they had standing, if they were in the top 99, we would entertain the case and get into the merits, but they weren't even in the top 99. So therefore, they're not affected by it. They don't have standing, or without standing, the court doesn't have jurisdiction to even entertain the case.
And I got to tell you, if I'm the lawyer, I'm reaching out to anyone else to just add someone to this case to say, hey, I'm already suing on behalf of 2 others. Maybe you want to come in just so you get standing. I mean, standing, just so you understand, standing, so viewers understand, is a threshold first issue, right? It's not waivable. You can't, even if you don't raise it, the court still has to consider it. And
it's a jurisdictional issue.
Yep. And I've won and lost a number of cases where the court comes out and says, I don't think this person has the right to raise the issue. And here's the issue. So, okay. So unfortunately, I'm going to, chalk that up to, I don't know. It does nothing for us, but okay. If you're a lawyer, make sure your clients have an injury in fact. Okay. So now we almost finish up our cases we're going to head to Illinois. Where a fire department was cited by OSHA, and I can go through some of these facts pretty interestingly. But look, if every department doesn't sit around and read all of the OSHA, NIOSH, incident reports, you're missing the best possible way to learn about every procedure you should have. And I do. I read these consistently because one of the things I do, and I think Curt does, you do, is we talk about must-have policies, but this is also must-have procedures. And there are certain procedures you need to have, even though they may not be mandatory. You at least need to have judgment being made on a scene considering certain things. And this set of facts kind of goes there. I have to tell you, this is one that I'm not going to express and I just want to be clear as I talk about the facts. I'm not expressing any decision, operational, good, bad, or otherwise. I don't think anyone's reading this who wouldn't say, "Wow, that was a gutsy move to go in," and yet might not have done it. Some of the questions, as you'll see, are should you have had a hand line, etc. But so here you have a fire department who gets a call. Possible structure fire, I guess. The first chief arrives on scene, says we got heavy black smoke pushing, right? They got a fire. And this is a department, it's a combination department, and the volunteers, at least almost every volunteer here, arrives in their personal vehicles. To the extent that makes a difference, it does, because you don't necessarily know, or maybe they use I'm responding, who knows, but you don't necessarily know who's arriving on the scene and how many you have. Now, it wasn't a huge issue here, but when you don't know how many people are coming onto a scene, you have a 2 in, 2 out question, right? That 2 people can enter as long as there's 2 people outside for rescue. And if you don't know who's coming, it's hard to make the argument that I've got 2 outside. Nonetheless, they take a defensive operation to a pretty good 2-story house fire. And by the way, this has got Black Sunday written all over it for so many reasons. The, Curt and I are historians of a lot of fires, as every firefighter should be. But the, Black Sunday is in a modified building. And it was the landlord's fault, not FDNY's fault, that they didn't, in the Bronx, they weren't able to look at this building being all chopped up and modified, and the plans and code enforcement and all that were ineffective. Here, they also faced a similar charge, but the fire department faced the charge that you should have done better pre-planning of this. That's not easily said, as we know. You don't always know what's happening. If there's no building permit, you assume there's no reason to go and look again if there was no permit. I don't know whether there was or wasn't. In any event, so they, and I apologize for being all over, but the chief pulls up, heavy smoke. The police are around back. And at this time, volunteers are arriving one at a time on scene with their turnout gear. The chief's got command, and the police around the back say, we got people in the window, I think on a 2nd-story window, and they didn't speak English well. There is a definite language barrier. So the chief grabs another firefighter. One is probationary, and then another firefighter arrives, and now they got 3, and then a 4th one arrives, and now they've got a full crew, some would argue, but they all arrive there, and the chief's calling for more help. The chief is saying we need a ladder truck. He says we need a ladder for sure, but he's giving orders. He's going to pack up. Right, he's gonna. I don't mean this in a derogatory fashion. He's gonna abandon command or turn it over maybe to the next new unit, but he's gonna surrender command by going inside to make a rescue. I don't think anyone can argue with that. And he packs up with the other interiors. He goes around. He observes the female in the window on the 2nd floor. The 4th firefighter arrives at this point. He says, "Okay, don up. We're gonna go in." The police are trying to talk to the victim at this time, but they have the language barrier. And ultimately this goes bad. So what happens is now a ladder truck arrives, right, shortly thereafter, and is directed to the rear of the building. In any event, the interior crew, let me kind of jump near the end. The interior crew goes in, tries to make a search. They are ahead of the hand line, ahead of being, there's no hand line behind them, even though they had initially stretched one. They didn't bring the hand line with them. There's nothing that anybody should take, right, in this video about criticism or not. We'll talk about the hand line for a moment, and I want to keep this more legal than operational, but it's hard to separate the two. In any event, they're trying to make the push, and everything goes badly. They're getting statements, transmissions over the radio that it's getting hot in here. you know, and they're trying to get him out, find a window. He could feel this thing's going to flash or go badly. And a few minutes later, the chief's vibro alert is going off and sounding. So that, you know, people got lost in here on the second floor. Finally, the chief, I think it was, found an exterior window and did break the window and I think exited. But, you know, we lost firefighters here. So they to describe what you're hearing inside, to see how bad this was, they describe as hearing roaring sounds. I mean, that when a firefighter, for those of us who have heard it, and there's many of us, it was roaring, you know, you don't want to be there. You definitely, you know, you don't want to be there. And they knew it was, the conditions were coming down quickly. In any event, he yells out, one of the firefighters, recognizing this and hearing this, is yelling for a ladder. He doesn't have a radio. And now I was surprised that didn't get more play in here, because to me, the 2 in, 2 out rule, this is only my interpretation, but let me stop here for a second. The 2 in, 2 out rule requires that when you have 2 firefighters in, and if that they be in voice or visual communication with 2 firefighters outside. This is exactly the situation I use when I say I believe federal regulations, the 2 in, 2 out rule, when I think that's 1910-134, but with the respiratory protection.
It
I
is.
think that's
It's
where
part
they
of
house it.
1910-134.
Yep. So there I interpret it to say, listen, there's no way there's visual communication. Let's scratch that off in a fire. And voice communication ain't going to be yelling. So every firefighter has to have a radio. I'm not saying that I've ever seen OSHA interpret it that way, but my interpretation is, how can you enforce the 2 in, 2 out rule without every firefighter having a radio in case one gets lost, exactly as happened here?
Yeah, it's actually a little bit more complicated, in that there's a connection between the NFPA and OSHA, and it has to do with the general duty requirements. The OSHA does not allow radios. Okay, so basically under OSHA, you have to be in visual, signal line, or voice communication. That's it. There is no radios permitted. Now that's between the 2 in and the 2 out.
Correct.
The NFPA allows radio, and OSHA defers to the industry expert. They consider basically the NFPA to be the industry expert, so they will allow radio, but on the 2 in, 2 out, not if you go 3 in, which was what they did here. They did 3 in, 1 out.
Right.
And those 3 cannot be together on radio. They have to be together either physically, voice, physical touch, or rope.
And people ask me, this is my belief, but people ask me, why is that, right? And what I remind everyone is, you got to understand the fire brigade standard and the respiratory protection standard are for industrial fire brigades, where they go into one room, not a mile into a house, down in the basement, up on the second floor. They're going to one room.
Or the 20th floor in a high rise, or any of the, any of the other places. Yeah,
so
absolutely.
These rules weren't meant for interior structural firefighting. They're meant for commercial firefighting, so they don't translate well. And
in fact, OSHA did not cite them. They did not cite them for a 2 in, 2 out violation, even though they violated 2 in, 2 out. They didn't cite them for it.
Right.
So,
I think they should have been, but shouldn't have been. Okay. So in any event, people jump, injuries, deaths, etc. But
no deaths, just injuries.
Oh, I'm sorry. Right. Fractures, severe fractures. Everyone's jumping out the window.
Everyone suffered at least one fracture. From my reading of it, it looked like all 3 of the firefighters who jumped suffered a fracture.
I don't think the ladder ever made it to that window. I think they just jumped.
I think it got the woman. I think the ladder got the woman, but they weren't close enough. I'm not sure the report actually got into the civilian aspect of it. They were focused more on the fire.
Ground ladders in place, but it's located to the side of the window. So so they didn't place it properly. I don't want to comment too much on that. I'm a little surprised. I don't want to be critical, so I'm going to leave that there. I'm not sure why that happened. In any event, let's look at the causes. Now, OSHA separates these into indirect and direct causes. Indirect less severe than a direct cause, but let's start with some indirect causes. And I'm just going to run through them. And some of them, okay, fine, but how much is the fire department's fault? So they talk about the municipality, and this is a municipal department, combination department. The municipality did not have active fire code enforcement program. and the building was identified in a pre-plan as a high hazard building, but no inspection documentation was able to be produced. I could come up with a million reasons, good or bad, that would or wouldn't have happened. We don't know. But there was a pre-planned building in 2011. Of course, since then, I think it had been modified, but the pre-plan was on file, but it wasn't reviewed at the incident. Some of that is, does the incident commander have the ability to pull that up on scene? There's enough computer programs out there where you can do that. On the other hand, if you're this chief, I can see not having the time to pull up the pre-plan necessarily, right? And when somebody screams, hey, we got somebody at the window, I'm thinking I don't need a pre-plan to grab them if I can grab them from the window. But in any event, again, the OSHA is being good. These are indirect things. So they said there are a number of written procedures and guidelines that are missing, including incident command, structure, fire response, and Mayday firefighter rescue. Again, these are indirect. Sometimes they make these direct responses or direct issues. They said there's a lot of training deficiencies, no training officer, no training schedule, no training policy. Now that one, I'm going to say, lack of training is always a direct issue to me, but they placed it indirect. I don't know how the department doesn't have one, whether that really was an effect or not here, who knows. But they say there's no size up in 360. That probably is, that's true. I don't know how much time they had or not, but they're saying there should have been a size up, and we know first arriving should always do a size up. They're saying that the initial arriving officer didn't assume command as required and achieve a strong command presence. Look, that could be an experience, etc. We know in the volunteer world and shorthanded world, sometimes the person in the front right seat is not always experienced. There just happened to be one of the few people who arrive. I'm not excusing that. They said there was not a predetermined automatic mutual aid system. That one, to me, I got to tell you, is unforgivable. I don't mean to them, unforgivable generally in this modern age, but yet there are still so many departments who don't have a CAD system because, they're millions of dollars. They don't have a proper system to set up a pre-planned box alarm, but, that's one that could certainly be handled. They keep going on that they say they entered the building without a hose line. And look, that's one of the things that Black Sunday taught us, that the truck crew or the rescue and search crew should not get too far ahead of the hand line or don't remove the hand line. And Black Sunday said, if we had a hand line, we might not have had to jump out.
My grandfather told me he would kick my ass if I ever went in a building without a hose line with me. And that was 50 years ago when I first started as a volunteer in North Providence. He said, you don't go in a building without a hose line. And that was way before Black Sunday. That was way before a lot of the things that we learned. And he was absolutely right. You do not go in a building without a hose line. That is your umbilical cord. But at any rate, that's
right.
But well, OSHA has all these wonderful
criticism
recommendations. Okay, the citations I think are the legal connection here. And oddly enough, they didn't incorporate a lot of those recommendations or almost consider a lot of those recommendations. And I think on one level, they went kind of easy on the fire department. They cited them for some procedural issues, one being lack of medical exams for the firefighters who were wearing respirators, lack of training, lack of
and by the way, those were repeat. You got it. Those aren't in themselves serious, but they were a repeat violation, which is the problem.
Right. And they're technical. So it's I thought it was kind of ironic that the OSHA came up with all these things that they pointed to, but then they didn't cite them for any of those. They really went after these sort of, to me, lack of fit tests, lack of, annual training and all that. So at any rate, but here's one I'd like to kind of just mention for a second, because I've seen this for 20 years. It's been in NFPA 1500. It's been in OSHA even longer than that. And it's the organizational statement requirement. And it's something that a lot of fire departments, I would say not a lot, 99.9% of fire departments don't have. but it's a requirement that the organization, the fire department, have an organizational statement that essentially establishes, the authority of the fire department, what the fire department is going to do, and OSHA really wants it to go beyond that. And I know NFPA sort of puts it on steroids and requires you to have policies and procedures outlining who you're going to send to, or basically what apparatus you're going to send to certain types of incidents, how many people you're going to send to certain types of incidents, how many people are going to be assigned to each evolution, such as stretching an attack line, stretching a feeder line, ventilating a roof, and all those things. And to me, it's so important. It may seem like it's a picayune little type of procedural requirement. It's so important because now a fire chief has to sit down and say, well, we've only got 3 firefighters. They're at 3 different stations. They're really just the drivers, but now they're going to be going to this, possible house fire. And so now I got to put in writing, how are 3 people or 5 people or 7 people? How are 7 people going to put out that fire?
Right.
Well, we're going to put 2 people are going to do this and 2 people are going to, and then we're out of people. And then you've got to sit down with the powers that be and say, we got a problem. OSHA requires me to have this organizational statement. NFPA requires me to have this organizational statement. How do I explain in writing how 7 people are going to put out a building fire?
Right.
It can't be done. It can't be done.
21 minimum.
It can't be done. It can't be done. And I think that's why, even if you're knowledgeable about the need for it, many fire departments say, oh boy, I don't want to be the one that's got to have that conversation with the mayor or the town manager or all that to really address those issues. So this is one of the first, if not the first, citation I've seen for a violation of that organizational statement requirement. And I think it's, tip of the cap to OSHA in Illinois for making that statement about the importance of that organizational statement requirement. I don't think most firefighters recognize it. To me, they couldn't have picked a better or more important section in OSHA to cite them for. And hopefully now fire departments will start paying attention to that. Well, I know, but you've got to basically find, if you say, all right, we've got 7 people. We know that at a typical one single family home, we need an attack line, we need a backup line, we need simultaneously, we need water supply established, we need to ventilate, we need primary search, we're going to secure the utilities, and we need EMS with 7 people.
Right. Never going to happen. You're not going to get 21 minimum people there. So
then you got to figure it out. Then you got to at least get them responding within a reasonable period of time, or figure it out. Right. But
look,
at any rate,
hope is
I'll get
not
off my soapbox.
No, you're right. But hope is not a tactic, and we survive on hope. The interesting thing is this was a combination department. So here it's I don't know where the career people are, right? Because it seems like everyone here is a volunteer. Maybe they're on the
chief,
ladder. I don't
the
know.
chief, the driver of the first in apparatus, I believe, was the fire chief. And
okay.
So my reading of it said that. So
I'll buy that. I will tell you, if you don't have the organizational statement, I just finished with policies. I'm working with a place in Nebraska. And, we start with the organizational statement. I said, if you don't have one, then you can't do a risk management analysis, right? You can't, without knowing what services you're going to provide, you can't talk about
what's an organizational statement.
Yeah,
I know.
But it's so common. I always think I'm going to bore people like, hey, we're going to start with the organizational statement. They're like, what's that? And I'm like, no, it's not a mission statement, right? I constantly, it's not a mission statement. Okay, so the last one we have for the day, we don't have any more cases. Right. We have the state of New York, who and my suggestion is twofold on this. A, we should punt just a little bit without getting too much in detail, because I don't think this gets vetoed. As of this morning, this is not signed by the governor.
Right. Let's talk about it. We're building the drama. Let's tell them. New York, it looks like they're poised to become the 4th state to enact a law that restricts photo taking at certain types of emergency scenes. The other 3 states, starting with the first one was Connecticut, followed by New Jersey, Those were both in around 2012, 2013. And then California, 2 years ago, after the Kobe Bryant crash, they basically made it a criminal offense for first responders to take pictures, or certain types of pictures, at emergency scenes. And there was a response to firefighters and police and others taking pictures that infuriated the families and the public, and so on. So that is how the legislatures in Connecticut, New Jersey, and California responded to that. There was an outcry after an incident in FDNY, or FDNY's EMS division, right, back in around 2009 also, that spurred the Wimmer family, and the person who was killed was Carolyn Wimmer, but Carolyn Wimmer's family had been lobbying the New York legislature to adopt a similar law that would prohibit police, fire, and EMS from taking pictures at emergency scenes. My understanding, not even my understanding, my guess is that the police and fire lobby was able to hold that law off in New York. Then there was another fatality, and let me get the woman's name was Bianca Devins. She was murdered in 2019, and the murderer posted the pictures on social media. So it wasn't a firefighter, it wasn't a police officer, it wasn't EMS, it was the murderer. And that caused people to kind of take a step back. And what they did in New York, and I hope if other states are going to do it, they kind of follow the same thing. What they did was they didn't go after police and fire. What they said was, if you take they basically said, because Carolyn Wimmer was the victim of a murder. She had been strangled, and the EMT took a picture of her dead body with a hairdryer cord wrapped around her neck.
Off-duty cop or something like that, right?
Well, he's a retired NYPD detective. So, but bottom line is, everybody makes mistakes. That's, that's behind us, and he actually got charged criminally and all that. So, point being that it looks like they're going in a slightly different direction here, which I think could be ways that other fire department unions and others who are lobbying legislatures around the country that may want to enact these kinds of laws. It's probably a better direction to go, is that what they're outlawing is anyone, not just police, fire, EMS, anyone taking a picture of a crime victim, okay, in an area where that person believes they have privacy. So it's not going to happen on a street, but in somebody's home, in some area, maybe a hospital, doctor's office, someplace where they're in a private area. If you take a picture and you share it, it violates the law. There's 3 degrees of criminality in it, and I'll turn it over to you.
Let's stop there for a second, because that's important. So the 3 degrees, as we're talking, go from, and it's not the highest one, which is scary, it's the lowest one. It goes all the way for you intended to cause harm to the person or the person's family by disseminating the photo, or all the way down to a lower crime, still a crime. It had no legitimate purpose for posting it. In other words, you did it for your own gratification. Look, I was on the scene, or look at the stuff I'm doing, but I could come up with a lot of questions, and I'm going through this law. That's why I said, I can do a lot more soon, and I'm going to do a video session on this for the New York departments who want to watch it, hopefully by the end of next week, once I'm out of trial. But there are a lot of questions that come up that I don't think are answered by this. What is a public area? So, for example, look, if there's a car accident on a street and I drive by and I take a picture of it, one, is it a crime scene? I don't know, right? And so I didn't intend to violate the law because I didn't know it's a crime scene. But two,
well, it doesn't criminalize taking the picture.
It's posting,
right?
But,
it's
posting,
but
I don't necessarily know, what the scene is. Now, the other question is, what's public? What if the fire department shuts the scene down, shuts the road down? Is that public? Is that not public? What if it's off the road and we drape it and tarp it? Public?
I would, I think the law was crafted to avoid the First Amendment issue, because the First Amendment will prohibit government from limiting people from taking pictures. But the First Amendment isn't going to apply inside someone's home. It's not going to apply inside the back of an EMS unit. or other places where a person has an expectation of privacy.
But let me keep going. So let's talk about drones. I think this is a growing, as I start realizing all the problems that people didn't think about. Drones, if you fly a drone above someone's fenced in property where EMTs are working on a drowning, is that public? Is it not public, right? For code enforcement purposes, you got a fence, it's not public. You can't scale or peek over the fence. So maybe there are some issues that are so obvious they don't need to address them. But I have a lot of EMS and fire specific concerns that I think people better be careful of. But let me tell you, you've got a house fire where nobody's getting through. I've cut off the streets. Not even the reporters are getting through. I'm saying that's not public anymore, right? Maybe for the neighbors. So that's the question. And yet one of my firefighters, he's only there because he's acting as a firefighter, pulls out his phone and takes a picture of a burn victim or somebody in a whatever, right? Or a person who's not even a victim yet, whatever that definition is. And then, he's got this on his phone. So now, right, the taking of the picture isn't the problem, the dissemination is. But if he sends it in a tweet, if he posts it on social media, clearly a problem. If he sends it in a group chat, I've got real questions.
I'd advise him not to.
Right. But, what's dissemination? So I have a lot of very specific questions about this. But look, the rule should be don't be an idiot and don't be insensitive. And we'd have no issues. But people want to take pictures of this stuff and treat it like, oh, look at my day. It's no different than standing in front of someone's house burning down and say, hey, look at us. Or putting on social media, great fire, right? As opposed to good work, great fire. People don't see this the way we see it. And glorifying a victim or glorifying tragedy is what this is intended to stop. So I agree 2,000% with, I don't know if I agree with the criminality of it, but I agree 2,000% with the law and the prohibition. I just think there's some questions that are not clearly answered. And I'll deal with those later, but yeah, it's a good stab at it. No pun intended.
I'm so happy. I'm like, when I first heard, you were the one who told me that Carolyn's law was going forward. I'm like, oh crap, here's another law that's going to be, it's going to be directed at police, fire, and EMS. Right. And I was so relieved when I saw that it wasn't. And that the direction that they went was really, I think, in probably a more productive way, that yes, firefighters could violate it, but it wasn't directed at us. So I like that. Now, if we can address those nuances, or the law can address those nuances. I know the concerns I have about Connecticut and New Jersey are the two that concern me. The California is a little bit less, because the California law only applies to pictures of dead bodies. Whereas the Connecticut law and the New Jersey law don't require dead bodies, just pictures of victims. So you could have a live victim. And at any rate, I think that the New York legislature is going in the right direction. If they can tweak out those distinctions that we need, I think they won't. Yeah.
The courts will, but they won't.
Is your mom still in the legislature?
No, it was my father who was in Senate, so no.
Oh, okay. I thought your mom was in the legislature as well.
She was a county commissioner. She was head of the Department of Youth, so she would have definitely had a number of issues where this came up with. But so anyway, good for New York State. I'm hearing rumblings it might not be signed out of some concerns, but I think it gets signed. It just, it could be months, it could be days, but. So we don't know just yet, or they might send it back to some corrections.
Well, maybe once it gets signed, assuming that it does this session, maybe they'll send it back and it'll come out next year or whatever. They'll tweak those issues, and we can have a more in-depth discussion. I'm sure you're going to do one for your clients as well. So that's great.
We're going to put one on the site once it's signed. Once it's signed, we see the final. So very good. That's it.
All right. Yeah, that'll do it. And that'll do it. It's been a long one. That'll do it for another edition of Fire Law Roundup. And we'll see you all. And again, please subscribe, help us to grow, and help us to be able to keep doing this.
Tell your friends, tell your mother.